circle this semester in thinking about the subject of belief at the Penn Humanities Forum. We began this year with Alex Boraine, co-chair with Archbishop Desmond Tutu of South Africa's Truth and Reconciliation Commission. While Boraine focused his talk on issues related to belief in the fundamental principles of democracy, much of his own thinking, writing, and public engagement in public life has grappled with how to deal with horrific acts of violence perpetrated against humanity in the 20th century. Today we welcome to the forum Harry Reicher, teacher, lawyer, scholar, and another extraordinary individual who has dedicated his life to the pursuit of justice for those who have suffered from a range of the worst forms of institutional and state violence. Born in Prague in the former Czechoslovakia, Reicher grew up in Australia, where he quickly established himself as a leading expert in international law and taxation. He has appeared in the High Courts of Australia and England and participated in numerous landmark cases in the area of international human rights, international environmental law, and Australian tax and corporate law. In addition to his important professional work as a lawyer, Harry Reicher has taught at a variety of institutions in the United States. In particular, this includes the Brooklyn Law School, Rutgers Law School, and the University of Florida School of Law. He has published 4 books. Law and the Holocaust, Cases and Materials is in its 5th edition. The Middle East Conflict and International Law is in its 6th edition. International Human Rights, The Freedom of Religion, and he has edited a book entitled Australian International Law. In addition to the books, Reicher has published several articles, papers, and chapters in books and journals on the subject of the relationship between Australian and international law, international environmental law, on Australian Aboriginal legal rights, and several pieces that examine the relationship between the secular legal system and Orthodox Jewish belief as it pertains to the State of Israel. Reicher is the Director of International Affairs and representative to the United Nations for the Agudath Israel World Organization, and an adjunct professor of law at Penn's own School of Law. The Agudath Israel World Organization is a confederation of Orthodox Jewish communities founded almost 9 decades ago. The organization is actively engaged with the promotion of international human rights with a special interest in religious freedom. It was founded in Europe in 1912 by a group of rabbis and grew in the 1920s and 30s to be the political, communal, and cultural voice of this group of Orthodox Jews. The first US branch of the Agudath Israel World Organization was founded in the 1930s and organized its first conference in 1939. The US-based AIWO is actively involved in lobbying all levels and branches of government, from the President of the US through Congress to the Supreme Court, on issues they believe to be crucial to their own community. Harry Reicher plays a central role in this regard. In fact, he made a series of powerful arguments recently in support of financial compensation awards, not just for individuals and families victimized by the Holocaust, but indeed for those cultural institutions, educational and religious, that have sought to rebuild Jewish life and identity in post-Holocaust Europe and America. Today, Harry Reicher comes to talk to us about the problem of the frailty of memory in courts of law, concerned with awarding financial compensation to survivors of the Holocaust. As Reicher argues so powerfully in his written submission regarding compensation for Jewish cultural institutions, it was not just that the Nazi regime murdered 6 million Jews, but that it destroyed an entire culture and a way of life embodied in a range of humanly constituted cultural institutions. In so doing, the Nazis also silenced entire archives of orally transmitted and humanly remembered bodies of knowledge and history. It is not just the ravages of time that have whittled away the archive of Jewish culture. The Nazi regime destroyed significant repositories of humanly transmitted traditions and practices. All that remains are frail fragments of memories, hidden in the crevices of the human mind, rarely retrieved either because they are too painful to talk about, or because large sectors of society have lost the capacity to comprehend the devastation and empathize with the depths of suffering. Some have gone so far as to suggest that the Holocaust never actually happened. The trouble with these remembered fragments is that for justice to be executed and compensation awarded, human memory is necessarily subject to the stringent standards of legal evidence. We live in a culture where the truth must be rendered as the perfect replica of an actual moment. Human memory must produce the photographic image of a past experience. This is impossible with Holocaust survivors. Harry Reicher is here to help us understand how the judicial system overcomes the problem of the frailty of memory and the struggle to recall. And the title of his talk today is Holocaust-Era Testimony, Frailties of Memory and the Eliding of Belief into Recollection. I welcome Harry Reicher.
That was quite remarkable. I have to say that I sent Carol and the Penn Humanities Forum about a tenth of what you just heard. So the moral of the story is, if I want to know what I'm up to, come to the Penn Humanities Forum. It is actually a great honour for me to be here tonight. Over the 8.5 years during which I've been associated with Penn Law School, I've come to admire immensely the sterling work of the Penn Humanities Forum and the remarkable intellectual challenges that it throws up in its series of lectures and presentations, and I really am very honoured and quite humbled actually to have been invited to participate this year. I thank the organisers immensely, and I also take this opportunity of thanking Ms. Maria Smolka-Day and Ms. Merle Slyhoff in the library at the University of Pennsylvania Law School for their tremendous help in getting some of the material that was relevant to tonight's presentation. And I also thank a wonderful graduate student from Ireland, Ms. Leanne Woods, for her research assistance. When we speak of memory, we obviously don't mean something concrete and tangible. Yet it's very much a part, indeed a core part, of our beings, no less than our heart, our head, our arms, our legs, and other limbs. Surely it is a fundamental part of who we are and what we are. In our memories, we aggregate what we've experienced over the years, what our senses have perceived, what we've seen, what we've heard, what we've touched. We aggregate in them our emotions, the emotions that we have felt, the thoughts that we have thought. Our memory is therefore at or very near to the centre of what defines us. Regarding the Holocaust, for so many survivors and for so long, memories were deeply and intensely personal, not shared with even their most intimate loved ones. The reasons were many and varied. The trauma for some was so violent they were stunned into a silence. There was at the same time a desperate urgency to establish and rebuild their lives in a new country, who had time to think, to ponder, to dwell on the past. There was also for some a sense of shame for having been party in a terrible way, as victims even, to this horrific tragedy. Yet those memories, bottled up for so many of them, were nevertheless central to their beings. In more recent years, there's been a tendency to open up, to share those memories, and there has, as a result, been a relative outpouring of writings, memoirs, diaries, archival manuscripts, more recently, taped testimonies, both audio and video. Often, the titles given to these memoirs, etc., are exceptionally beautiful, moving, evocative titles, ranging from Elie Wiesel's Night to Nechama Tek's Dry Tears, to the autobiography of a survivor whom I met in New Jersey a year and a half ago, whose work is entitled My Middle Name is Israel, recalling every moment that he looks at that book, that when he was in Nazi Germany, he was forced by law to amend his name by including the name Israel in the middle. In this way, survivors let us in on their memories, let us in on their lives, let us in on their inner beings, and as a result, we ourselves are enriched immeasurably. They contribute to our understanding of a horrifically dark not only to understand, but also to identify and to empathize. They give us a direct, immediate, and personal insight into the impact of a massive campaign to discriminate against them, to ostracize them, to dehumanize them, and eventually to eliminate them. These memoirs help us to move from the abstract to the concrete, from the general to the particular, from a figure of 6 million to a figure of 6 million times over, and therefore to touch us more directly, more immediately, more personally, and through that to awaken in us an appreciation of the form and intensity which human suffering took during that era, an appreciation of the depths to which human behaviour is capable of sinking, and in some shining examples the heights to which it can rise. The memoirs can also inspire us to action, awaken in us an ambition to summon our knowledge, our talents, our expertise, to marshal all of these and to take concrete steps in any way that we are capable of taking to avoid a repetition. But Holocaust memories are at the end of the day like all memories. They repose in human beings. They're products of human psyches. That's their greatest strength. They are human. They reflect an intense humanity. But it's also a potential source of weakness. Human memories are like human beings themselves, imperfect. They exhibit normal frailties. None of us remembers everything that we see or hear or experience. We do forget things that we did remember. Normal frailties are exacerbated by the effluxion of time. Memories fade, but not always. Sometimes we retain them in the most vivid form. Age seems to accelerate that fact. More and more often we experience what are delicately and with more than a touch of euphemism referred to as senior moments. And yet we can often have no difficulty recalling with great precision things that happened many years ago. And then there's the problem of assimilation, hearing things described, seeing things on film, on video, in photos, reading about them in books and newspapers, all with such detail, all with such apparent accuracy, so that after a while we begin to assimilate what we have seen, what we read, what we have heard, assimilate into our own memories. We read, we see, we hear, therefore we believe, and belief elides into memory. And yet at other times we have no difficulty delineating clearly and with great precision where our memory ends and where belief begins. These and others then are some of the issues of memory. Memory can be a great blessing, but forgetting can also be a great blessing. When we speak of time healing all wounds, don't we really mean that sometimes, perhaps often, memories of unhappy and unpleasant experiences and events fades, and with it the pain we have endured? But again, not always. Sometimes just the opposite is true. All of which is to say that memory is a strange and rather elusive phenomenon. So the question for us is, how does all of that relate to the Holocaust and to Holocaust memories? The answer, I believe, is it depends very much on the context. And I think one can isolate 5 contexts in which Holocaust memories are particularly relevant. So let's take each context individually and examine it, then survey some of the key issues regarding memory that emerge from the literature to the extent that I, as a mere lawyer, have been able to understand it. And then let's weave those observations into those 5 contexts. Finally, I will try to develop a continuum ranging from rigid legalism to unabashed compassion to apply to each of these 5 contexts. Context number 1, criminal prosecutions. One of the first imperatives, one of the first priorities in the immediate aftermath of the Holocaust was to bring perpetrators to justice. The Allies had foreshadowed this very clearly on November the 1st, 1943. The 60th anniversary of the Moscow Declaration was commemorated just over a month ago. In it, the Allies warned the Axis powers that they would be held to account for the terrible atrocities which were being spoken of and described. Not all agreed with that. The British War Cabinet, for instance, meeting in solemn session, decided it preferred what it called a political solution. And by political solution, they meant taking them out and shooting them. Thanks to President Truman, thanks to Justice Robert Jackson of the Supreme Court, trials were held. The perpetrators were brought to justice, to the bar of justice, with three goals. Number one was to set a precedent in international law and thereby send a message to would-be Hitlers. Secondly, to develop a comprehensive historical record for future generations. And thirdly, the moral goal of distinguishing our behaviour from theirs. And that led to the Nuremberg trials, the progenitors, if you like, of today's international tribunals for the former Yugoslavia and for Rwanda. Those trials at Nuremberg dealt with two categories of evidence: documentary evidence and personal testimony. The major trial of the major war criminals was conducted largely on the strength of documentation. But international law is enforced not only through international tribunals, rather also through national tribunals. And a model, so far as the Holocaust is concerned, is the trial of Adolf Eichmann in Jerusalem. That, in contrast to the Nuremberg trials, was conducted very significantly on the basis of oral testimony by witnesses. An example of the importance of eyewitness testimony comes from the evidence of Yechiel Dinur, known by his nom de plume, Katsetnik. He wrote very movingly, very poignantly, after the Holocaust about his experiences in prose and poetry. And when it came the time to try Adolf Eichmann, he was asked to testify. He wasn't sure that he could survive it emotionally. The experience of reliving what he had gone through. The Attorney General of Israel, Gideon Hausner, who led the prosecution, went to see him personally and persuaded him that he had an obligation to come to the trial and testify, because he was one of the very few people who had actually seen Adolf Eichmann in Auschwitz and could locate him there physically. Eventually he agreed. But when he came, he stood there in the witness box and was asked why he had chosen to write under the name Katsetnik. He said that wasn't a nom de plume. And he started talking about the planet Auschwitz, in which the normal rules of humanity were suspended. And in the course of his testimony, very dramatically, he collapsed in what the commentators at the time called a paralytic seizure. Extremely dramatic when one sees it, but there was an example of the importance of eyewitness testimony, dredging up memory in order to bring a perpetrator to justice. He died about a year and a half ago at the age of 84. When we talk about the International Military Tribunal at Nuremberg, when we talk about the Eichmann trial, we're talking about criminal trials. In both cases, the ultimate penalty was available, the death penalty. The Nuremberg War Crimes Tribunals were set up under a charter which allowed for the death penalty to be sentenced and imposed. In Israel, the Nazi and Nazi collaborators punishment law provides for the death penalty. It's the only law in Israel that does. But whether the death penalty is on the line or whether the maximum sentence is life imprisonment, as is the case in the tribunals for the former Yugoslavia and Rwanda, the criminal law quite properly views trials of alleged Holocaust-era perpetrators with the utmost seriousness, and therefore it imposes on the prosecution the strictest standards of proof beyond a reasonable doubt. That standard has important implications for evidence consisting of individual testimony, subjected as it is to the frailties of memory. Individual testimony in these cases goes to two areas: the identification of the defendant and the facts and events which the defendant is alleged to have perpetrated. An important recent example of this was the case of John Demjanjuk, which started in the mid-70s and continued on and off until the early 90s. Demjanjuk is a Ukrainian-born auto worker who lived in Cleveland for many years after the war. He was charged in this country with being Ivan the Terrible of Treblinka. The Office of Special Investigations in the Justice Department moved to strip him of his citizenship and deport him. Israel asked for his extradition, and he was in fact extradited to Israel to stand trial for his acts at the Treblinka death camp about 100 kilometers from Warsaw. It was an extermination camp from July 1942 until August 1943, with gas chambers equipped and disguised to look like fake showers, and something of the order of 850,000 Jews were put to death in that camp. I've seen a low estimate of 800,000 and a high estimate of 870,000. The tribunal in Jerusalem accepted 850,000 as being close to the correct figure. The charge against Demjanjuk was that he operated the gas chambers and that he tortured his victims. And one of the elements of the evidence against him was eyewitness testimony. Eyewitness testimony that identified him and described what he did from eyewitnesses. One of the eyewitnesses, when asked to say whether this man in the dock, Ivan Demjanjuk, was also Ivan the Terrible, walked over and asked him to remove his glasses. He looked into his eyes and he said, "There is no shred of doubt whatsoever," quote unquote. Another eyewitness talked about the 11 months during which he had, quote, lived together with Ivan the Terrible. They were confined in a relatively small space. The events, he said, are deeply engraven in my memory. A person doesn't change that much, certainly in terms of basic features. I can't free myself of him. I think of him every day. I dream of him at night. On the basis of this testimony and a lot of other evidence and refutations of his defences, Demjanjuk was found guilty and sentenced to death. He appealed. Between the trial and the appeal in the Supreme Court of Israel, relations between Israel and the Soviet Union thawed, and additional evidence was made available from the Soviet Union. And that evidence indicated that there was another Ivan Marchenko, who appeared to have been Ivan the Terrible. The evidence from the Soviet Union was very unsatisfactory. None of the people who were said to have made these comments identifying Ivan Marchenko were available for cross-examination. Either they were dead or couldn't be located. Their evidence couldn't be tested in the normal way in which evidence is tested. Nevertheless, the Supreme Court found that the material from the Soviet Union cast enough doubt regarding these particular charges, and on that basis, the guilty verdict was overturned. Although, very interestingly, the court found that the evidence showed, beyond a reasonable doubt, that Demjanjuk had in fact served at two other death camps, Sobibor and one other one. Nevertheless, the appeal was allowed. That's an example of a criminal prosecution where the standard of proof is very, very high. And in the Demjanjuk case, the Supreme Court of Israel clearly demonstrated that, notwithstanding the eyewitness testimony which had been firmly and unequivocally accepted by the trial court. Context number 2, quasi-criminal cases. The Office of Special Investigations moves to strip Nazi perpetrators in this country of their citizenship and to deport them. The basis being that they lied on their applications to enter this country and hid their Nazi pasts. A good example is the Fedorenko case in the late 1970s and into the 80s, which went all the way to the Supreme Court of the United States. Fedorenko was also a guard at Treblinka, and he was charged with having persecuted Jews in that death camp. The district court description of Treblinka resonates. Quote, "It contained only living facilities for the SS and the persons working there. The thousands who arrived daily on the trains had no need for barracks or mess halls. They would be dead before nightfall. It was operated with a barbarous methodology, brutally efficient, and such camps surely fill one of the darkest chapters in the annals of human existence, certainly the darkest in that which we call Western civilization." Eyewitness testimony was also extremely important in the Fedorenko case. 6 witnesses positively identified Fedorenko, including one of the witnesses who had testified against Demjanjuk. One witness, Eugene Turovsky, testified that he saw Petitioner shoot and whip Jewish prisoners at the camp, said the court. Another, Sholom Cohen, testified that he saw Petitioner almost every day for the first few months Korn was at Treblinka, that Petitioner beat him with an iron-tipped whip, and that he saw Petitioner whip and shoot other prisoners. The third witness, Joseph Chardny, claimed that he saw Petitioner beat arriving prisoners, and that he once saw him shoot a prisoner. Gustav Boraks testified that he saw Petitioner repeatedly chase prisoners to the gas chambers, beating them as they went. Boraks also claimed that on one occasion he heard a shot and ran outside to see Petitioner with a gun drawn, standing close to a wounded woman who later told him that Petitioner was responsible for the shooting. Sonia Lefkowitz testified that she saw Petitioner shoot a Jewish prisoner. Finally, Pinchas Epstein, who testified against Demjanjuk later, testified that Petitioner shot and killed a friend of his after making him crawl naked on all fours. Fedorenko ended up being stripped of his citizenship and deported. In the course of the Supreme Court's decision in this case, the court laid down a stringent test, setting a very high threshold. The government, said the Supreme Court, carries a heavy burden of proof in a proceeding to divest a naturalized citizen of his citizenship. The evidence justifying revocation of citizenship must be clear, unequivocal, and convincing, and not leave the issue in doubt. The reason, said the court, is that citizenship is the most basic right. The Supreme Court itself has, in another case, described citizenship as, quote, "nothing less than the right to have rights," unquote. The court might have added that loss of citizenship also means deportation, and deportation can lead to the severest of consequences. Fedorenko himself was deported to the Soviet Union. There he was tried, there he was convicted, he was sentenced to death and executed. The same fate would have befallen Demjanjuk if not for the new evidence from the Soviet Union and the decision on appeal. That's a second context. Context 3, administrative proceedings or processes. I'm referring here to applications for reparations and compensation. One example consists of applications to the Claims Conference, the Conference on Jewish Material Claims against Germany, which was set up a few few years after the war, in an agreement between the then Chancellor of Germany, Konrad Adenauer, and the Prime Minister of Israel, David Ben-Gurion, providing for lump sum payments for Holocaust survivors and also pensions. All of this is money that comes from the German government, and it operates by people filling in forms by way of application, setting out the basic facts, setting out their names, dates, events, places, a brief narrative describing their experiences. My experience in this has been considerable over the last 8 years, and I've seen that problems of memory manifest themselves in two ways, generally speaking. One is that people who came here as refugees in the late 40s and early 50s, at the time when the Claims Conference was just getting underway, in many cases didn't bother to apply. Didn't apply for a number of reasons, a variety of reasons. Some refused to apply on principle. They didn't want to touch German money. Others didn't apply because of circumstances. They didn't speak the language. They were unfamiliar with the environment, with their surroundings. They were enmeshed in the daily struggle to make ends meet, to establish themselves, to rebuild their lives, to remarry, to start families. They didn't have a ready supply of lawyers, ready, willing and able to contest claims for them, to pursue claims for them. They didn't have children who spoke English, who could help them, and so on and so on. By contrast, 40 or 50 years later, so many of these people, these same people, were by this stage in the 80s and the 90s, elderly, their health was failing, health insurance was inadequate, social security checks were not going far enough, and they heard what was going on. There was talk of billions of dollars in reparations and compensation. Lawyers were advertising. People were talking. And therefore they decided to apply, and they got the forms. Who can blame them for not being able to remember everything, all the details, all the place names, all the dates, to remember these and many other minutiae with the accuracy, with the degree of particularity required by these forms. And of course, inevitably, they made mistakes. And often for these reasons, their claims were rejected by the Claims Conference. People who did apply in the early years, they didn't succeed for whatever reason. For instance, the Claims Conference might have asked for more details which were never supplied. It was a daunting task. Everyone who's been a refugee or in unfamiliar territory can empathize with the circumstances of those people in the late 40s and the early 50s. And so they didn't pursue their claims. And again, 40 or 50 years later, they resumed their interest for the same reasons. But of course, no one thought to keep copies. Who knew what a photocopier was in those days? Who even knew how to make copies? And so they came to fill in forms, in many cases in the 1980s and the 1990s. And the obvious point is, who can fill in two forms 40 to 50 years apart and not get into discrepancies? Never mind the effects of the trauma, the language difficulties, and so on. These are the sorts of practical problems of memory which have been arising on a daily basis in the last 10 years or so. And the same applies in other analogous circumstances dealing with reparations and compensation programs, the Swiss bank settlement case, slave labour programs, and so on and so on. That is context number 3 in which problems of memory arise. Context number 4, the writing of history. Historians are trained to rely on and analyze different categories of evidence. One category of evidence comprises recollections of survivors in the case of the Holocaust. Increasingly so in the last decade or more, that has been the case, and one finds the Holocaust histories written in the last decade containing significantly more in survivor testimony, quotations, interviews, products of video testimony, and so on. The same applies not only in the case of the historians, but in my own work here at Penn in the legal dimension to the Holocaust. I teach a course entitled Law and the Holocaust, and among other things, I deal with the Nazi legal system, and specifically the pseudo-legislative system concocted by the Nazis, in which there was a veritable outpouring of laws directed solely and specifically and directly at the Jews, something of the order of 2,000 in the space of 12 years from 1933 through 1945. An astonishing figure in and of itself, made even more astonishing when one recalls that in 1933 the population of Germany comprised a little under 1% of Jews, and by a process of natural attrition and immigration that fell during the course of the 1930s, so that in 1939 it comprised a little under half of 1%, and yet there was this torrent of laws. And what I've done in my teaching materials is to develop 8 or 9 major themes, extract those themes from the legislation, and in the case of each theme, we start off examining the laws which were the principal pillars of that theme, and then the materials are followed by survivor memoirs, diaries, testimony of one sort or another, including material from archives, which demonstrate the direct and immediate and personal effect of these laws on the daily lives of Jews. All of this, in the work of the historians and work such as my own, all of this means that the issues arising from the frailty of memory potentially affect everything that we're doing. We'll come back to this. Context number 5, the final context, denying history. Those who would deny history, in this case, denying history in the sense of refusing to believe, denying positively that the Holocaust happened, or alternatively denying that the number was 16 but merely, quote unquote, several hundred thousand or whatever it was, notwithstanding, by the way, that Adolf Eichmann at his trial in Jerusalem estimated that 6 million Jews had perished during the Holocaust, and he certainly had no reason to exaggerate. Holocaust deniers are confronted with different categories of evidence. There is physical evidence, the gas chambers, the crematoria, the mass graves, etc. There is documentary evidence, mountains, indescribable mountains, even though they tried to destroy so much of what they had created in the latter part of the war, seeing the writing on the wall. Nevertheless, the bureaucracy had created this extraordinary, massive paper trail. And so that even if they were successful in destroying primary documents, there were inevitably 2 or 3 copies, in many cases, deposited with other departments, other ministries, and so on. But another category of evidence is Holocaust survivor testimony. And a standard weapon in the armory of the Holocaust deniers is to seize on the sorts of issues and problems with which we began, seizing on discrepancies and contradictions, often minor, however minor, seizing on them, both within the testimony of individual witnesses themselves, as well as among witnesses, seizing on gaps in recollection, seizing on examples of belief eliding into memory, and using these imperfections to impugn the testimony as a whole. A brilliant example took place, still around in the case of the Adjunct trial. A particularly nasty, unpleasant website has been set up in recent years, www.stormfront, it's one word, .org, And there's a case, History of Demjanjuk, under a section headed The Theatre of Lies, the John Demjanjuk case. It seizes on the Supreme Court's decision on appeal and extrapolates. The Supreme Court decision inevitably, they say, inevitably means that the Supreme Court dismissed the eyewitness accounts as lies. The case against Demjanjuk was, quote, fabricated from start to finish, and therefore the implication is that all of the Holocaust survivor testimony is suspect. They're all false. That's the extrapolation, and therefore ultimately the Holocaust never happened, after having disposed of other categories of evidence which we don't have to go into. It's a breathtaking leap of logic or illogic, and it falls at the threshold. The Supreme Court's decision contained no such implication whatsoever about the witnesses, bearing in mind the standard of proof is beyond a reasonable doubt, and it's an extremely high standard. What the Supreme Court was saying was no more than that, even accepting all the testimony as accurate, the new evidence from the Soviet Union, problematic though it is, being old, the people concerned not being around, the inability to test it in the usual ways by cross-examination and so on, despite all of that, and despite the fact that as a result we can't really know what it means, and therefore we can't make definitive findings of fact, nevertheless we are left with a gnawing doubt, and we can't send a man to the gallows on that basis. That is what the Supreme Court said, and no more. In the process, by the way, the author who wrote this piece on the website overlooks two things. One is that the Supreme Court said that it was clear that Demjanjuk was at Sobibor and Flossenburg, that was the other concentration camp. Even in his visa application, he named Sobibor as being one of the places where he'd been during the war. Under cross-examination in Jerusalem, he said, "It was a mistake, I meant Sambor." Secondly, it ignores that one of the things the case showed clearly was that the Israeli court system could be trusted to play it as it saw it. The decision of the Supreme Court was extremely unpopular, and there was in fact a petition to the Supreme Court by survivors of Sobibor to have him retried, this time on charges relating to Sobibor. Held no, and let him go. With all of that in mind, having sketched what I've called the 5 contexts, let me survey briefly the scientific work on memory and the lessons for our theme. I don't pretend a technical expertise. I am far from a psychologist, amateur or otherwise. I'm a mere lawyer, but I have surveyed quite a bit of the technical material and would suggest certain principles to be extracted from that material so that we can apply them to our 5 contexts. Principle number 1, there is no such thing as a perfect memory. It's trite, it's obvious, it goes without saying. There are only people with better or worse memories. There are only individuals with better or worse memories for certain things. Principle number 2, it's very difficult and even dangerous to generalize. That is, every manifestation of memory needs to be assessed on its own merits. And a corollary of that is that there is no individual factor or combination of factors that is necessarily determinative in a particular instance. And that leads directly into principle number 3, so that whilst factors such as age, effluxion of time, the nature and intensity of trauma may affect memory, the real question is always, do they affect memory in an individual instance, and even more particularly, the question is always, in the case of this particular witness, in the case of the testimony that that particular witness has given, has he or she been affected by these factors? And if so, how? In some cases, these factors may actually improve the memory. We've all experienced so many of these situations where the adrenaline is pumping, all our senses are focused in attention. And whilst we can't compare with the sorts of circumstances we're describing, having experienced something along these lines, we can begin in a very small way to understand that in some cases, these factors, a factor of trauma in particular, can actually improve memory. It follows, therefore, that none of these factors and others, or a combination of them, is necessarily a bar to credible testimony. Testimony, in other words, cannot be dismissed simply and solely because of these factors. Principle number 4. A variety of additional factors may affect memory. For example, disease, malnutrition, significant weight loss, belief gained from other sources, and so on and so on. But again, the question is whether it has done so in an individual case, and if so, in which way. Principle number 5. Studies have shown that certainly in some cases, Holocaust survivors have exhibited remarkable abilities to remember events clearly and accurately, both soon after the event and again after having been retested decades later, showing a remarkably high degree of consistency. Also, another theme emerging from the studies is the tendency to remember core facts better than peripherals. By peripherals, I mean things like dates and precise descriptions of details. In other words, all of this underscores what one expert called the malleable nature of memory. So to take an example, in Lawrence Langer's book Holocaust Testimonies, he quotes a survivor, Agudath. "I want to talk about a certain time not measured in months and years. For so long I have wanted to talk about this time, and not in the way I will talk about it now, not just about this one scrap of time. I wanted to, but I couldn't. I didn't know how. I was afraid too that this second time, which is measured in months and years, had buried the other time under a layer of years. But this second time had crushed the first and destroyed it within me. But no, today, digging around in the ruins of memory, I found it fresh and untouched by forgetfulness." We know, of course, that that is her subjective description, but the point is that it could well be objectively true as well. There is no inherent reason, is the point I'm making, why it cannot be objectively true. So the question is, where does this take us in terms of the 5 contexts? Applying the principles I've sought to extract from the scientific material to those 5 contexts, it seems to me that that leads us in the following directions. As far as context number 1 is concerned, criminal prosecutions. What emerges from the scientific studies is there is no such thing as perfect memory, to put it again. And again, it shouldn't come as any surprise. Memory resides in human beings, and human beings aren't perfect. Therefore, since human beings testify in court, there are no such things as perfect witnesses. As Mark Bloch put it in The Historian's Craft, there is no reliable witness in the absolute sense. There is only more or less reliable testimony. And the legal system recognizes this by, among other things, not requiring absolute certainty in arriving at its conclusions, even in criminal prosecutions, even where the stakes are at their highest. In other words, the legal system, recognizing the imperfection of human beings, does not require perfection. Rather, it accepts a certain level of doubt. It's a small level of doubt. The threshold to be proven is extremely high, but as long as the small threshold of doubt is not exceeded, the system can deal with it. And the law has devised approaches to determining whether that threshold has in fact been exceeded. And the starting point is the witnesses themselves. They start off by being presumed to tell the truth, but there are ways of testing that presumption. Photo identification is an example. Quite a few of the Holocaust cases have turned initially on identification of photographs. The laws of evidence have rules against suggestibility, against creating photo identification systems that suggest the answer to the witness. In other words, one looks to see that all possible photos that have been laid out before the witness have been laid out evenly. Is there any photo that is larger than the others and draws attention to itself? Is there any photo where the image is abnormally large compared to the others, again drawing attention to itself? Has there been any suggestion in the questions put by the person asking them, which leads a potential witness in a particular direction? And so on and so on. Another example of how the law tests witnesses is through cross-examination. We test the accuracy of the evidence, but we also test for truthfulness, for credibility. And an interesting example took place in the Demjanjuk trial itself. One witness positively identified Demjanjuk as, one particular witness identified Demjanjuk as Ivan the Terrible. Here, we see in the cross-examination of that witness a remarkable example of an application of the principle concerning core and periphery. Holocaust survivors being much more likely to remember with great clarity the core of their experiences as opposed to the periphery. That principle immediately suggests a strategy to a defense attorney cross-examining a witness who has positively identified his client. And in this particular case of Demjanjuk, defense counsel adopted that approach. It was to take the witness through the minutiae of Treblinka, to walk that witness, as it were, through the place where he'd been 40 years or more earlier. A lot of the details bore no relationship whatsoever to the defendant, Demjanjuk, including in particular one question: where was the laundry hung? To which the presiding judge objected. He said to him, to the defense attorney, we are talking about a place where 850,000 people were put to death. Haven't you got anything better to ask him? I'm paraphrasing, he didn't put it quite in those terms, but he said to him, we're talking about a place where 850,000 people were put to death. It was important from our purposes, this exchange, because both were right. Defense counsel's job is to shake the witness's account, to cast doubt on his recollection, and also to rattle the witness himself in that case, because if he could be made to doubt that his memory was really accurate, perhaps he could be shaken on his core testimony, which went to the identification of Demjanjuk. all intended to sow the seeds of doubt. Where better a place then than the peripheral information where the witness could be pretty sure to be at his weakest? So defense counsel's strategy was correct, but so was the judge's, because a court always retains a discretion to exclude testimony that is not relevant to the issues before it. And so, by stopping the questioning on the peripherals, what the judge was saying was, these peripherals are totally irrelevant to what is relevant to Ivan the Terrible, his identification and his act, and all of their relationship to Don Demjanjuk. A fascinating example to my mere lawyer's mind. And when it comes to testing the evidence, the role of the expert witnesses in this is important. There was a very thoughtful Dutch psychologist who was an expert on memory, Wagenaar, testified. He was called on behalf of the defense. He wrote a very thoughtful piece later on about his experience, and he explained that he wasn't there to talk about memories of the Holocaust or to assist in any way along those lines, but rather simply to talk about the issues of memory, specifically as they relate to Holocaust testimony. He was there to talk about principles, he was there to talk about generalities. And for that very reason, he couldn't form a judgment regarding the reliability in a particular case. And he said so. He said deciding whether a particular witness is credible is really up to the court. An expert can help with isolating the factors to consider. An expert can help in explaining to the court and really conveying to the court what the latest research says about these factors. But at the end of the day, after the witnesses have testified, their testimony, after the witnesses have testified and after their testimony has been tested in the ways I've described, then the court has to decide based on the test beyond a reasonable doubt. What that suggests is actually a strategy, an important strategy for defense counsel in these sorts of cases. In the extraordinarily unlikely circumstances that I were ever engaged as defense counsel in one of these cases, I know what I would do. I would seek the leave of the court to have all the witnesses examined psychologically to see whether in the case of these particular witnesses in relation to these particular events and circumstances, I could shake the testimony or shake their credibility. Context number two, what I've called quasi-criminal proceedings, in particular deportation proceedings. The Supreme Court in this country has averred that the test is substantially identical, quote unquote, to the criminal law standard beyond a reasonable doubt. The reasoning is the same. We're talking about very serious potential consequences, and therefore we treat it all with the utmost seriousness. What that means is that everything that I've just sketched in relation to context number one, criminal proceedings, also applies to quasi-criminal proceedings. Context number three, administrative proceedings, through applications to the claims conference and the like. Here we have a very different situation. The stakes are very different, really small for the most part, certainly compared to the stakes in other situations that we've looked at. We're talking about pensions and payments that are far from huge. In the legal world, once one is out of the criminal standard of beyond a reasonable doubt, one is into the civil standard on a balance of probabilities, meaning colloquially 50% plus one, a very, very different way of looking at evidence. And therefore we can afford to be more relaxed, we can afford to be less rigorous, we can afford to permit greater departures from absolute certainty, especially since the core recollections are likely to be accurate. We can tolerate greater discrepancies at the fringes and even to a certain extent within the core itself. What this is really is a plea for compassion and less insistence on legalism. Experience shows that instances of outright lying are few and far between in these circumstances. And if they're picked up, then the applications are simply rejected and should be rejected. Context number 4, writing history. There is, of course, a need for historical accuracy for the sake of history itself, but the historian is entitled to rely on the survivor's testimony in whatever form, without subjecting it to the sort of testing that is appropriate in a court of law, especially in criminal proceedings. If there are discrepancies, if there are contradictions, if there are inconsistencies, as is inevitable from time to time, then an historian is trained to deal with that, to test the issues that arise by reference to documentation, by reference to corroboration, seeking corroboration, by placing the testimony in historical context in order to work out which version is most likely to be correct. And if there's still confusion, then for the historian, that is the conclusion. There is confusion, there is uncertainty. And that being the case, considerable leeway is warranted. And then context number 5, denial of history. The starting point for the deniers of the Holocaust is twofold. Number 1, they start with malafide. If not initially, then they're developed later on. And a conscious attempt to debunk whatever evidence gets in the way of their theses. Secondly, from our point of view, in our terms, they set a standard which is beyond perfection, impossibly high, inhumanly high, and they regard any departure from it as fatal. They seize the slightest discrepancies and inaccuracies and conflicts in testimony. And if one takes this approach to its logical extreme, then one gets to something said by John Zimmerman in his book Holocaust Denial, Demographics, Testimonies and Ideologies. There's a chapter headed Victim Testimony. Here's what he says. One of the most contentious aspects of Holocaust denial is that of eyewitness testimony. Such testimony is often easy to criticize because eyewitnesses may be mistaken as to certain factual circumstances of incidents they witness. Anybody familiar with the John F. Kennedy assassination is acutely aware of the problems which surround eyewitness testimony. There were 178 witnesses who gave testimony to the Warren Commission about what they saw and heard in Dealey Plaza on November the 22nd, 1963. 49 heard shots from the book depository, 21 from the now well-known grassy knoll, 30 heard shots from other sources, only 4 witnesses heard shots from more than one direction. By applying the techniques of Holocaust denial to the Kennedy assassination, it could be argued that since there was so much contradiction as to the source of shots, President Kennedy was not really shot at all. The important thing to keep in mind is that while witnesses may make errors as to certain factual occurrences of an event, they are often correct as to the occurrence of the event itself, core versus periphery. Thus, even though there was a wide divergence of opinion among the witnesses as to the source of the shots, nobody would seriously claim they did not see Kennedy being shot. The 5th context. And that leads us it seems to me, to suggest what I would like to, namely a continuum. It's a question of striking a balance between two considerations at either end of the continuum: rigid justice on the one hand and unmitigated compassion for the victims at the other end. So when one takes contexts 1 and 2, criminal and quasi-criminal prosecutions, that is close to the first end, to rigid justice. And that's the way it should be, because the stakes are so high, not requiring absolute certainty, but only that small degree of uncertainty being tolerated, which the law is prepared to find acceptable. At the other end, I would place the Holocaust deniers in terms of absolute, unmitigated compassion, I should say, for the victims. Cutting Holocaust deniers no slack. So whatever compassion is there should work in favour of the victims. And somewhere in the middle, contexts 3 and 4, context 4, closer to context 1 and 2, the role of the historian being to present as accurate a picture and as accurate an interpretation as possible for posterity. And context number 3, the administrative procedural process, closer to number 5, where compassion for the victims should override rigidities, excuse me, as required by the legal system in other directions. I have finished. I can hear you, yes. The acoustics are fabulous.
I wonder if there is another context, which is a context of memory in the making, which is the current event, and how the fictive media, in effect, determine what our memory of the event will be.
Yes.
To take a lot of examples, you see our bombing of Baghdad, but we didn't see all the killings before our...
Moulding, shaping memory, yes.
So do you have any thoughts about how we should conduct ourselves and our institutions in life and say that we are creating memories for the future?
Thank you for that observation. I would actually pull that in within one of the categories that I developed. Certainly, when we talk about the issues of memory, we talk about memories being shaped by outside forces. And if you give me your name later on, I will footnote you when I elaborate on that, when I eventually get around to writing something on this, because it's a very important point, and it's a uniquely late 20th century, early 21st century point, isn't it? We read about how images in the media have had seminal effects on wars. The withdrawal of United States troops in Somalia followed a terrible graphic photo of an American being dragged along the street. We remember the images from Reuters and Associated Press in the Vietnam War. And some of the horrific photos have actually been reprinted in recent days in the context of stories about the sort of theme that you're developing. The famous shooting of a Viet Cong suspect and the moving, affecting story of the child running naked with arms raised, getting out of, away from the fire. Where this leads to, I think, as a lawyer, is the testing of memory. When recollections begin relevant, then these sorts of effects have to be isolated out and put to a side so that real memory is allowed to come to the fore. What I have in mind is this, that one of the ways of testing accuracy of testimony, one of the ways of testing credibility is through cross-examination. And that's why hearsay evidence is inadmissible, because I can't cross-examine on what someone else said to this witness. I can cross-examine on what that witness heard and read and saw, but unless the person who passed on the information is there, I can't test that evidence. And this seems to fall to me, to fall within that overall theme, the importance of being able to test witness testimony for accuracy and credibility. Yes.
I'd like to ask a really, frankly, very sensitive question, which has to do with bad faith.
With?
Bad faith.
Yes.
And as a historian, if one is going to interview someone and try to get their account of something, part of the suspicion is that they may deliberately misrepresent themselves because they may be ashamed of something that happened, or they may
Yes.
be bad. They're not going to be, it could be one of two kinds. It could be bad faith of deliberate misrepresentation, or it could be bad faith of, let's say, kind of an unconscious desire to repress something.
Or what we would regard as legitimate reasons for misrepresentation.
Or legitimate reasons of representation. So that's from a historical point of view. And then you move it into a court of law, and then there's a moral moment when you ask the question, not whether the president was shot, not whether the Holocaust happened, but how do you, as a lawyer, interrogate someone who may be engaged as a witness who is a Holocaust survivor in an act of bad faith?
And what is critical is having the material to be able to demonstrate that bad faith. Once one has contradictory evidence of one sort or another, or other material, then the way one goes about it is, as you started off, very delicately, because for a number of reasons, one of which, not the least of which, and perhaps the most important of which, is an advocate who is cross-examining is constantly conscious of the need not to alienate the tribunal. And if someone has been through horrific experiences, the last thing you want to do is get them sobbing in the witness box. It's not going to do your client any good if you happen to be a defense attorney. So what one needs, and their real diplomacy comes to the fore, and one can do it. One can put contradictory evidence to witnesses in ways that can't be said to be provocative and can't be said to be mean-spirited. The question then is what you do if you don't have contradictory evidence, but you have a suspicion that someone is giving evidence in bad faith. And there a good cross-examiner knows how to lead a witness through the facts, including the core facts, in order to raise doubts about whether this person really does remember this in the way that was said. Again, without alienating anyone. It's an exercise in diplomacy, but good advocates know how to do it, ma'am. Along that continuum, the more serious the offence and the more serious the consequences, usually the two go together, the greater the care that must be taken to ensure that the right person is convicted. it's often very, very unpleasant. It was a very unpleasant thing for the Supreme Court in Israel to let Demjanjuk go, especially after it was clear to them, to that court, that this guy had certainly been at Sobibor. Whatever doubts there were about whether he'd been at Treblinka or not, he'd certainly been at Sobibor, which was just as bad. As we move away from that sort of situation towards crimes of lesser import, misdemeanors you call them, excuse me, so you move away from the necessity of most rigid application of the rules. The stakes are less. Yes, ma'am.
I wonder, looking forward, about the malleability of evidence. Digital photography and work, there are all sorts of
Yeah.
new...
Yes. Absolutely. Morphology was an important element in the evidence at the Demjanjuk trial. And it was quite a revelation to me to see how this was done. They took a photo of Demjanjuk from his visa application to the United States, 1951. They took a photo of him taken at the time of the trial, and they superimposed one over the other. And it was astonishing. You could see that the distance between the eyes, for instance, was the same, and the shape of this, that, the other, all the same. And then they had the experts, and this is the key to your question. They had the experts get in the witness box, and one expert was cross-examined so intensely that she broke down and started crying. She was asked, "You're not an expert on photography, are you?" "No." "You're not an expert on physiology?" "No." "Then will you tell the court what you are an expert in?" And it was a very, very aggressive cross-examination. Another witness got in the box and spoke about the probabilities of having the following features match on two photographs taken at such a space of time. So the answer to your question is that the technology that allows this is also capable of being tested in the traditional ways, albeit applied to that technology. Every expert in morphology has another expert who's willing to say something different. I wouldn't quite put it that way, I'm exaggerating, but that's the point I'm making. In other words, whilst the nature of evidence has changed over the years, the basics about evidence and the testing of evidence are still good. There was some fascinating evidence in the Demjanjuk trial, for instance, about the SS card that had been issued to him when he finished his training at Travniki camp, and the Israeli defense lawyer who led the team got up and very flamboyantly said to the court, "We're going to take this document apart. We will leave nothing in its place, not the photograph and not the signature and not the staple on the photograph and not this and not that." And the judge injected a note of humour. He says, "I hope you're not going to tear up the photo itself." He said, no, that's the one thing we're going to leave in place. And then witnesses got up from England. There was this elegant, studious man, probably in his 60s or 70s, pontificating about the staple and the distance of the holes between the holes where there'd been a staple. These are ways of testing that sort of evidence, and the same principles apply to morphology. Gentleman up the back.
I want to come back to the civic question
Yes.
earlier about
Yes.
we talked about the impact of media on witnesses,
Yeah.
forming their memory. But what about the impact of media images on lawyers, judges, and courts in trying defendants? Wouldn't it put defendants at an unfair advantage if, for instance, they were trying war crimes of genocide in Rwanda, and the court, the judge, and the lawyers had all seen images from the genocide in Rwanda. So they came in actually with a visual memory of that event already. How do you mitigate that influence, not in the witnesses themselves, but in the court?
It's a question which is all pervasive because the media are all pervasive. We can't help but see these sorts of images. The answer lies in focusing very strictly and very carefully on the issue before the court. The issue is not whether an enormous tragedy happened in Rwanda.